Welcome back, everybody. It's the lawyer you know, and today, after lots of comments and requests for discussion, it's finally time to dive into the Kyle Rittenhouse case. And we've waited until now because this trial starts in almost exactly 1 month on November 1st. So it's time for us to dive in, see what he's charged with, see what his defenses will be, see what the evidence is against him, and give our little preview of that trial before it starts. And then if you guys are interested, let's put the gun emoji in the comments for obvious reasons, because this case has a ton of political pressure, a ton of media attention, and a ton of outside forces closing in on it, right? It's a lot about pro-gun, anti-gun, pro-protest, anti-protest, BLM, white supremacy, all sorts of stuff is kind of combined and intertwined in this case. So let's put a gun emoji in the comments if you want us to continue talking about this case, especially once the trial starts. And if you do, we will do a trial update like we've done on the Ronnie O'Neal case, the R. Kelly case, the Elizabeth Holmes and Theranos case. We will do those trial updates on this Kyle Rittenhouse case if there is interest. So make sure you subscribe to our channel so you don't miss out on any of this, and like this video if you're into the Kyle Rittenhouse case. So where we start any criminal case is with the charging document in the criminal complaint. So we're gonna pull it up on the screen to see exactly what Kyle Rittenhouse is charged with. A lot of us know from the videos, from the news, from the media attention that he shot some people at a protest, right? But what did they charge him with? Was it first-degree murder? Was it accidental killing? Was it manslaughter? We know he was underage with a gun. What all did they originally charge Kyle Rittenhouse with? Let's get into it. Count 1, first-degree reckless homicide and use of a dangerous weapon. Okay, so that's not an intentional killing. This is reckless killing is like a little bit worse than accidental killing, but not intentional homicide, at least for count 1. And you can see that this is for the death of Joseph Rosenbaum, okay? And it was under circumstances which show utter disregard for human life. And the potential sentence for this is a term of up to 60 years in prison. But then there's a second paragraph, and further, invoking the provisions of section 939.631B, Wisconsin statutes, because the defendant committed this offense while using a dangerous weapon, the maximum term of imprisonment for the felony may be increased by not more than 5 years. What we call that is an enhancement or an additional penalty because he used a dangerous weapon. And you're going to see a common theme throughout all of these counts that paragraph is going to be included because we know he used a dangerous weapon. Count 2, first degree, recklessly endangering safety. So not murder, but endangering safety and use of a dangerous weapon. This is surrounding Richard McGinnis, who is a reporter and one of the main witnesses referenced throughout this charging document. And the potential prison sentence for this is up to 12 years and 6 months under circumstances which show utter disregard for human life. Again, and then again we see he committed the offense while using a dangerous weapon, the maximum term of imprisonment increased by not more than 5 years. Let's get to count 3. First degree intentional homicide. That is first degree murder, intentional murder, premeditated killing, and use of a dangerous weapon. The above named defendant, on or about Tuesday, August 25th, 2020, did cause the death of Anthony M. Huber with intent to kill that person, which, as we all know, for first-degree murder, a potential conviction can get you life in prison. And then we have the additional use of a dangerous weapon. Again, as I said, it's going to be throughout most of these counts. All right, count 4, attempted first-degree intentional homicide and use of a dangerous weapon. So this is attempted first-degree murder. So the defendant attempted to cause the death of Gage P. Grosskreutz with intent to kill that person. Again, up to 60 years in prison and an additional 5 years for use of a dangerous weapon. Count 5, first degree recklessly endangering safety. Now, a lot of this makes sense because he's shooting a gun with a crowd of people with all these people around, so they could have charged it different ways. This is how they decided to do it. The defendant did recklessly endanger the safety of an unknown male under circumstances which show utter disregard for human life. Looking at up to 12 years for this, plus 5 for the use of a dangerous weapon. And then last, count 6, possession of a dangerous weapon by a person under 18, okay? And he can get up to 9 months in prison for that, for count 6. So we heard him talk about 3 different men and an unidentified male. So where are they getting this information? Where are they getting this evidence? Why are they charging him with these counts? Well, the evidence that was provided in this criminal complaint were cell phone videos and recordings and statements of multiple witnesses, one of whom was McGinnis, the reporter that was around basically for most of this. And let's get into it. And again, the reason there's an unidentified male is he didn't get hit. It was an attempt for him. He didn't get hit. He left. They never identified who he was. He was wearing clothing. They saw him in the video and you couldn't really tell who it was. And they never found out. So he just becomes an unidentified male as a victim in this case. All right, let's talk a little bit about what they found. We're not going to go through it in painstaking detail, but let's just kind of get through what they've got. Okay. In the video, the defendant can clearly be seen holding a long gun, which was later recovered by law enforcement, identified as a Smith & Wesson AR-15. The video shows that Rosenbaum, okay, and we're going to focus on both sides of this, right? Because we're going to talk a little bit about what Kyle Rittenhouse's defense is, and in this case, as you might have heard, it is self-defense. So let's talk about what the evidence shows with self-defense and what the prosecutors are going to use in this evidence. So the video shows that Rosenbaum appears to throw an object at the defendant. The object does not hit the defendant, and a second video shows that it was a plastic bag. Rosenbaum appears to be unarmed for the duration of this video. All right, so let's just think about that, and this is how it's going to come out in trial. They're going to show a video where Rosenbaum looks like he's throwing something, doesn't hit him, it's just a plastic bag, and Kyle shoots him. But in self-defense, a lot of this has to do with the defendant's perception of what's going on and whether a reasonable person would have been in fear for their safety in their life. So in this video, when all the chaos is happening, when somebody's throwing something at you, is that going to be enough to defend yourself? And if so, what level of defense? A shove, a punch, a kick, a run, or a fatal shot? Because that's what he's got to prove, that he used the right level of defense in this case for the fear that he had, for the fear of bodily harm that he had. So that's going to be really important throughout this case. Let me know in the comments as we go through this. Do you think a self-defense is going to work in this case based on these facts that we're going to see in this criminal complaint? Did he fear for his safety enough to act in the way that he did? All right, a view of the second video can show that the men keep running through the parking lot. Rosenbaum yells, "F you." He appears to continue to approach the defendant, gets in near proximity, when 4 loud bangs are heard, and then Rosenbaum falls to the ground. Then the defendant circles back and approaches Rosenbaum, who remains on the ground, and that's when McGinnis approaches. Okay, McGinnis removes his shirt, tries to render aid, and the defendant can be heard saying, "I just killed someone." There's more evidence of that he said, "I just killed someone." I don't think he's going to dispute that someone died. Usually you don't do that in a self-defense. You admit the action, but you say, it was not a criminal action because I was defending myself, but yes, I did kill someone, but I did not intentionally murder someone, right? So that's going to be an important distinction throughout this case. All right, so let's talk about what McGinnis saw and what he testified to. He talked a little bit about how he saw the defendant. He told him he didn't think he was handling the AR appropriately, but he did say that Rosenbaum initially tries to engage the defendant, Rittenhouse. He stated that Rosenbaum was actually trying to get closer to the defendant. And when Rosenbaum advanced, the defendant did a juke move and started running. McGinnis stated that there were other people there and everybody was moving very quickly. He stated that a lot of them were moving toward the defendant and he saw the defendant trying to evade the individuals. So that's going to be a big thing that comes out in trial. Did he try to flee? Did he try to leave? Because fatal self-defense, deathly self-defense, killing someone in self-defense should be a last resort. It shouldn't be your first option. If someone comes up to you and puts your finger in your face, you don't shoot them, right? You run or you push them out of the way or you try to get away from the situation. You don't shoot them because that's not in fear of death, right? In fear of serious bodily injury at that point. But it seems here McGinnis is saying he did try to evade him. So McGinnis described that the defendant got the gun in a low ready position. He heard the defendant fire 3 rounds. McGinnis felt something in his leg. He got shot in the leg. McGinnis testified that the first shot, it seemed like went into the ground and then maybe hit McGinnis in the leg, but that eventually Rosenbaum, the victim, lunged to grab the gun from the defendant. That's when the defendant shot Rosenbaum and Rosenbaum hit the ground. Okay, again, is that enough to be in fear of your bodily safety or bodily harm when somebody reaches for the gun that you have? All of these things are going to be questions for the jury. McGinnis stated after the defendant shot, he ran back toward the hospital. McGinnis stayed to try to help Rosenbaum. More videos, okay? Show people yelling things at the defendant like, hey, he shot him, get that dude, he just shot someone, and other expletives. Then, the defendant eventually trips and falls to the ground, as we all know that we've seen these videos. As the defendant's on the ground, an unidentified male wearing a dark-colored top and light-colored pants jumps over the defendant. This is the unidentified male. He fires some shots at him, but this guy gets away unharmed. And then Anthony Huber approaches the defendant, who's still on the ground on his back. Huber has a skateboard in his right hand. When Huber reaches the defendant, it appears he's reaching for the defendant's gun, and the skateboard makes contact with the defendant's shoulder. He appears to be trying to pull the gun away. The defendant rolls and eventually fires one shot. Huber staggers away, and he subsequently dies from this gunshot wound. So we all remember the guy swinging, or the guy with the skateboard, pulling the gun away, gets shot. He eventually dies. That's one of the charges. And the video shows this. So again, a guy running at you with a skateboard, is that enough? If he hits you on the shoulder with the skateboard, is that enough? If he tries to grab your gun, is that enough for self-defense? That's what this trial is going to be all about, is what was Kyle Rittenhouse going through, and were his decisions to shoot and kill these people reasonable under these circumstances? That's what a jury is going to have to decide. So after shooting Huber, the defendant moves to the seated position, again, still on the ground, points his gun at a third male, later identified as Gage Grosskreutz, who had begun to approach the defendant. And when the defendant shot Huber, Grosskreutz freezes and ducks and takes a step back. He puts his hands in the air, but then he moves toward the defendant, who aims his gun at him and shoots him, firing one shot. Grosskreutz was shot in the right arm. A lot of us can remember that from the video. But Grosskreutz appears to be holding a handgun in his right hand when he was shot. I think that's important, right? The first guy was totally unarmed. Second guy only had a skateboard, right? So they were unarmed. But then, if a guy's got a gun, does that change the circumstances? Does that put you in more fear for your safety and for your life? Historically speaking, and based on case law, if somebody else is armed coming at you, there's a much higher likelihood that it's reasonable that you could be in fear for your safety and bodily harm, rather than somebody throwing a plastic bag at you. I don't know what was in the plastic bag. I don't even know if it was a plastic bag, but that's what they said Rosenbaum threw. Just happened to be a plastic bag. A lot less scary than somebody coming at you with a gun. But again, there's so many factors here that we've got to discuss and think through, and I want to know your opinion in the comments about all this, because you all are potential jurors in cases like this, which is why I love this channel and this type of discussion. Because we have lots of people that have lots of different diverse thoughts and backgrounds and experiences that I want to know what you think if you were in the position of Rittenhouse, or if you were in the position of these victims. What would you think? Do you think any of this was reasonable, or do you think he's cooked and there's no way a jury buys self-defense? Then they talk about how the medical examiner does say that these victims died of the gunshot wounds from the trigger pulled by Kyle Rittenhouse. So that's mainly what the charging document says, okay? Talked about his defense. Talked about self-defense. All these experts have come on and say, no way he gets self-defense because he fatally shot these people. Other people saying slam dunk self-defense. I don't think it's 100% either side. I don't think it's black and white. I don't think anybody's going to be able to call right now whether self-defense is going to be a winning argument or a losing argument. I think we have to see what comes out at trial, which leads me to the final motions and hearings of what's been happening and what's being argued before this case ultimately gets to trial on November 1st. So the first thing is, what evidence is going to come in? We know the videos are coming in. We know the witness statements are coming in. But the defense has filed motions asking the judge to allow them to get a self-defense expert to testify at trial, specifically talking about what police officers do in making their use of force decisions. So we're going to see if that comes into play here and what Kyle Rittenhouse did and whether or not it was appropriate. Then we have the prosecution trying to get in a video where you can hear Kyle Rittenhouse saying something like, I'll read the quote, but I'm not positive this is the right quote. Bro, I wish I had my expletive AR. I'd start shooting rounds at them. Okay, so they want to get that video in, but the defense is making a lot of arguments. Rittenhouse is not on the video. You can't see him. The person filming the video, you can't see them. It doesn't look like it's in Kenosha or anywhere near where this case happened. So they're arguing this is not relevant. This is highly prejudicial. And you may think, well, that never works for criminal defendants. However, in this case, the prosecution has tried to put in other social media posts, other social media pictures. Some of them they're going to get in. But one important one was a link to the Proud Boys page from Kyle Rittenhouse's page. And the judge determined that that is not going to come into evidence before this jury. But the prosecutor specifically making arguments about this video where he says, I wish I had my AR, I'd put rounds into them. They say it shows Kyle Rittenhouse's state of mind just 15 days before this shooting. That he is a vigilante and he's ready and willing to take lethal force even if it's unjustified. That's the prosecutor's argument. We haven't heard whether or not this video is going to come in. What do you think? Do you think this video proves anything about this case, or do you think it's just prejudicial and they're trying to use it to make him seem like a vigilante when it's just a 17-year-old kid talking? What do you think? Is it close enough to exactly what happened here to where it should come in at trial as other acts or other bad acts? How close do you think other bad acts need to be to come into this trial? Because if you got in a fight in high school and then you get accused of battery later on or domestic battery, do you think every high school fight you got into should come into evidence? Is that similar enough to this bad act? I don't know. Are you just bringing everything a person's ever done in their life to try to make them look guilty for this case? Or can we focus on what happened in this case? Can we prove this case just on the facts and the evidence surrounding this case? Let me know what you guys think. I know what lawyers think about other bad acts, but I want to know what you guys think. Do you think we should just be able to get in all the trouble everybody's ever gotten to in every case because once a criminal, always a criminal? Once a bad guy, always a bad guy? Let me know. So lastly, with this trial, beginning in just a few weeks on November 1st, and it's supposed to last somewhere around 2 weeks. Both sides have petitioned the judge and asked the judge if they can send jury questionnaires out to the potential jurors ahead of time, because they want to ask specific questions of these potential jurors to get everyone out that's going to have a bias, to get everyone out that's going to be a bad juror without wasting time bringing them in court with all the COVID stuff going on, all the publicity around this case. It is a high-profile case. Everybody's heard about this Kyle Rittenhouse case. So what's interesting and what people might not know about jury questionnaires is most of the time for almost every trial, juries fill those out. But they're very bland. They're very vanilla. It's like, have you ever been a juror before? Have you ever been convicted of a felony? Do you have any family members in law enforcement? Do you have a job? How old are you? Are you married? Those are the types of questions that are in jury questionnaires that go out in just about every trial. Most trials, we get those answers back beforehand so we can look through and see if we recognize anybody so we can strike them. If it's somebody that goes to my church or my next door neighbor, obviously they're not going to be a fair and unbiased juror for my trial, so we strike them and it saves time for judicial economy. But in some cases, we can actually give specific pointed questions. Questions like, have you seen these cell phone videos? Have you already talked to people about this case? Have you read any news articles about this case? If so, which ones? Have you seen anything on the news or in the media about this case? If so, what have you seen? What does it make you think, feel, etc.? Because we want to get that all out in the open before they come, because we don't want to have any jurors that have preconceived notions coming in and being a juror on this case. We want unbiased, fair jurors. So yes, the attorneys get to ask these jurors questions when they come to court during voir dire. We'll talk more about that when it happens in this Kyle Rittenhouse case. But these juror questionnaires can be very important because you can get a lot of information earlier on that will help you prepare for trial as a lawyer. You don't get to do it in every case. You don't get to specifically ask the court to ask certain questions. But in this case, both sides want to submit questions to the court. Now, when that happens, it can be complicated because I can object to what the prosecutor wants to ask. The prosecutor can object to what I want to ask, and we can have extra hearings and take extra time in trying to figure out exactly what questions are necessary and admissible to ask potential jurors. So sometimes judges don't want to deal with all of that, so they just say no. But I think this is a case where it is necessary. We've had some high-profile cases where it's taken weeks to pick a jury because we've had to go through each individual juror, comes in the courtroom alone, sits in a chair. The judge asks them some questions. Each lawyer asks them some questions. They leave. We talk about it all as the lawyers, as judge. Are we going to strike them? Are we going to hold them? What kind of strike is it going to be? Are we going to make them wait till the end? Each individual one. And we focus on the news. We focus on the newspapers, on media, on YouTube even these days, on the news channels of what they've heard, what they've consumed, and has it already shaped their opinion of this case? Do you think you'd be able to walk into this case as a potential juror, unbiased, listen to the evidence, and just make a decision on a verdict based on what you hear and see in trial? Or do you think you've already read and heard and seen too much and you feel like you're already kind of slanted one way or the other? It's okay. I think most people have, if they're being honest. And that's what I want to know, just with our community. How many of you do you think already are feeling slanted from one side to the other? I'm going to hold what I think is going to happen in this case until we get deeper into the trial and see if there is interest in this case from our community, and if you guys even want more content like this or more videos on this case, because if so, I'll be sure to do it, because this is a really interesting case to me. It's a high-profile case, and I'm interested to see what happens when this case actually goes to trial. But that's all we've got for our little intro to the Kyle Rittenhouse case and our trial preview. Let me know what you thought by leaving a like, subscribing, leaving a comment. But for now, that's all we've got. Thanks for being with us. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.